Good morning, Suraj Singh here. Jammu and Kashmir issue. Certain documentation I'm going to discuss with you is a revision of previous videos because many developers come in and one search on Google and found many more documents and many more, you can say, informations related to this state of Jammu and Kashmir, legal issues, legal issues. Of course, this is a difficult job to find all documents, but to support public and to provide information to public, I found necessary, considered necessary to do something on that, and just I have posted also on this text. You can see that one. Let us start list of documents because this is very important to know. Until we know history of this Jammu and Kashmir issue, we cannot understand this problem. And understanding the problem is very essential from each and every point of view. Without understanding this, we cannot know what's happening, what's not happening. So it's our duty to understand first, because without understanding, we can speak anything on hearsay, and hearsay is not enough. And we have to know what we are talking of. We should know that one. And just I'll speak this time. It's a Bharat India JNK Constitution of India Article 370 Bharat Jammu Kashmir Sanvidhan Anuched 370 हेतु विधान नियम अधिनियम. Once again I say Bharat India Jammu and Kashmir Constitution of India Article 370 भारत जम्मू कश्मीर संविधान अनुच्छेद 370 हेतु विधान नियम अधिनियम के बारे में. और यह है भारत जम्मू कश्मीर संविधान अनुच्छेद 70 हेतु विधान अधिनियम भारत के बारे में हम आपको बताने. आई एम जस्ट गोइंग टू टेल यू अबाउट दैट, बट आर रिकॉर्ड्स ऑफ दैट regarding the constitution and statute for this one. It's a general information of you, and you can search on web and you can find these documents. I put some references for certain documents, not all documents, and we have to just discuss it after I'm explaining to you what it is. It says that I'm just first speaking in Hindi, little very bad Hindi, and then I'll try, because I use both languages for purpose of all people. So it says that, let's say, भारत जम्मू कश्मीर संविधान अनुच्छेद 370 हेतु विधान नियम अधिनियम भारत इंडिया JNK Constitution of India Article 370 related Constitution statute etc. for information. And instrument of accession 1947 भारत में इंस्ट्रूमेंट ऑफ एक्सेशन 1947 भारत में जम्मू कश्मीर का प्रवेश होना 1947, जिसके द्वारा जम्मू कश्मीर राज्य का शासन चलता रहा है. दोहरा बोलता हूँ, इंस्ट्रूमेंट ऑफ एक्सेशन 1947 भारत में जम्मू कश्मीर का प्रवेश होना 1947, जिसके द्वारा जम्मू कश्मीर राज्य का शासन चलता रहा है. याद रहे कि रायशुमारी अभी बाकी है, जिसके नहीं होने पर भारत की स्वतंत्रता अधिनियम का उल्लंघन माना जाएगा. तथा इंस्ट्रूमेंट ऑफ एक्सेशन 1947 भी गैर नियमित माना जाएगा. इंस्ट्रूमेंट ऑफ एक्सेशन 1947 जम्मू एंड कश्मीर किंग भारत इंडिया इंसर्शन इनटू कॉन्स्टिट्यूशन ऑफ इंडिया पेंडिंग प्लेबसाइट रेफरेंडम ऑफ JNK पब्लिक. This is instrument of accession title. Now, what is background of that? I'll tell you later on. Now, instrument of accession 1947 की शक्ति को भारत संविधान में लाना. भारत संविधान 370 including IOA instrument of accession on Constitution of India for statutory reference and imparting legality to international agreement to national status. Then document is भारत संविधान की राज्यों सूची स्केड्यूल 1 भारत संविधान की राज्य सूची स्केड्यूल 1 कॉन्स्टिट्यूशन ऑफ इंडिया में भारत के हिस्से से कश्मीर को लाना, जिससे पाकिस्तान वाला कश्मीर शामिल नहीं है. JNK जम्मू एंड कश्मीर is included in schedule of Bharat India Constitution, which is a states list excluding POK. Part that is not in Bharat custody could not be included in Bharat India Constitution. Then संवैधानिक आदेश 1 से 48 का पास होना. संवैधानिक आदेश 1 से 48 का पास होना राष्ट्रपति द्वारा 1947 से 1954 तक, जिसके द्वारा 260 395 में से मतलब 260 बटे 395 अनुच्छेद भारत संविधान में है जम्मू कश्मीर पर लागू होना. 1947 to 1954 Constitution of India Constitutional Orders 1 to 48 empowering Bharat India when JNK agree for 260 or 395 articles be applied on to JNK. जम्मू कश्मीर राज्य को भारत इंडिया नाम के नीचे लाना. अनुच्छेद 1 भारत संविधान. JNK comes under name of ours Bharat India. दिल्ली एग्रीमेंट 1952 1952 का दिल्ली एग्रीमेंट सामान्य बातें जो 1947 से पहले बने नियमों को सुलझाता है, कश्मीर को अलग झंडा भी देता है तिरंगे के साथ तथा राष्ट्रपति भारत को मानता है। दिल्ली एग्रीमेंट 1952 फॉर कॉमन इश्यूज, फ्लैग फॉर JNK इन एडिशन टू नेशनल फ्लैग, रिकॉग्निशन ऑफ भारत प्रेसिडेंट बाय JNK, देन जम्मू कश्मीर का संविधान 1956 जो जम्मू कश्मीर को भारत में विलय करता है, कॉन्स्टिट्यूशन ऑफ JNK 1956 that integrates JNK into भारत इंडिया। संयुक्त राष्ट्र आदेश 1948, संयुक्त राष्ट्र आदेश 1948 जो भारत तथा पाकिस्तान को आदेश देता है कि जम्मू कश्मीर के लोगों की रायशुमारी कराएं, जो 2019 तक भी नहीं हो सकी। UN Resolution 1948 and revisions 11 times for referendum plebiscite from JNK public। शिमला समझौता 1972 जो भारत पाकिस्तान को अपनी समस्याएं आपस में सुलझाने का आदेश देता है तथा जब तक भारत पाकिस्तान दोनों लिख कर नहीं मांगे तृतीय पार्टी नहीं मना है समस्या सुलझाने के लिए। शिमला एग्रीमेंट बिटवीन भारत इंडिया एंड पाकिस्तान, शिमला एग्रीमेंट between Bharat, India and Pakistan to agree issue between two nations on bipartite basis exclusively with no third party interference required. Until both nations do not give in writing, no third party is required. Agra summit कोई फैसला नहीं, Agra summit conducted between Musharraf and Vajpayee with no result. लाहौर घोषणा सामान्य बातें, लाहौर डिक्लेरेशन कॉमन इश्यूज। जम्मू कश्मीर का संविधान 1956 जम्मू कश्मीर का भारत में विलय करता है का सुधार 2011 में, जिसमें सदर रियासत तथा प्रधानमंत्री का पद समाप्त होता है तथा कॉन्स्टिट्यूशन असेंबली के स्थान पर राज्य असेंबली को माना जाता है। JNK कॉन्स्टिट्यूशन अमेंडमेंट 2011 that depletes designations of king and prime minister as well as constituent assembly replaced by state assembly। 2019 में इंस्ट्रूमेंट ऑफ एक्सेशन का समाप्त किया जाना है तथा भारत का संविधान लागू मतलब जम्मू कश्मीर का संविधान 1956 जम्मू कश्मीर का भारत में विलय करता है का सुधार 2011 में, जिसके सदर रियासत प्रधानमंत्री का पद समाप्त होता है तथा कॉन्स्टिट्यूशन असेंबली का स्थान पर राज्य असेंबली ले लेती है, समाप्त किया जाता है तथा राज्य को स्टेटस समाप्त किया जाता है। 2019 President of India abrogates, removes Constitution of India Article 370 and Constitutional Order 1 to C, Constitutional Order 48, Constitutional Order 1 to Constitutional Order 48 and Constitution of JNK 1986 and follow up which are replaced by Constitution of India on the whole, J and K state converted into union territories, Constituent Assembly replaced by State Assembly and designation of King and Prime Ministers again replaced by Governor and CM, in addition to when affected by 2011 amendment not applicable by Parliament and President of no application of mine of by Parliament and President of India। Then जम्मू कश्मीर का संविधान 1956 जो जम्मू कश्मीर को भारत में विलय करता है समाप्त हो जाता है। एक कमेंट्स है, जम्मू कश्मीर का संविधान 1956 जो जम्मू कश्मीर को भारत में विलय करता है समाप्त हो जाता है तथा पाकिस्तान का हिस्सा भी समाप्त हो जाता है। भारत के नियंत्रण से पूरा जम्मू कश्मीर राज्य नियमित रूप से चला जाता है। तात्पर्य, भारत के पास कोई नियंत्रण नहीं संवैधानिक रूप से जम्मू कश्मीर के ऊपर। JNK Constitution is annulled by foregoing laws means JNK as an integral part of Bharat India is depleted। अगस्त 5, 2019 के आदेश के हिसाब से जम्मू कश्मीर राज्य अब भारत इंडिया का अधिकार में नहीं आता है। Foregoing references do not permit by law that JNK belongs to Bharat India anymore, effective 5th of August 2019। अब भारत के लोगों को मिठाई बांटने दो तथा डांस करने दो तथा मोदी मोदी करने दो, क्योंकि 1947 से 2011 के 1947 से 2011 के बीच में किए गए किराएदार पर पानी फेर दिया। Now Bharat India's people must celebrate by distributing sweets and conduct rock dances and chant Modi Modi because Modi has saturated all work that was done affected from 1947 to 2011। Now let's start with this. First of all, let's go back somewhere and see what happened in 1947. It's a very important one. From understanding you find in sequence so that we can be clear about this, because this is a complex problem and everybody is confused and people are just understanding this superficially. Nobody is trying to go into details of what happened, and it's very important to go into details to understand facts of in this case, without which we cannot realize what actually happened, what our Prime Minister has done, what our Parliament has done. All that requires such kind of analysis, understanding, which only people who use mind can do it. And that's the reason that I'm trying to inform public what actually happened. Let us start with Maharaja Hari Singh's letter to Mountbatten, text of letter dated October 26, 1947, from Hari Singh, Maharaja of Jammu and Kashmir, to Lord Mountbatten, Governor General of India. Once again, I repeat, Maharaja Hari Singh's letter to Mountbatten, text of letter dated October 26, 1947, from Hari Singh, Maharaja of Jammu and Kashmir, to Lord Mountbatten, Governor General of India. Let's see now. It is dated 26 October 1947. My dear Lord Mountbatten, King writes, I have to inform you, Your Excellency, that a grave emergency has arisen in my state and request immediate assistance of your government. As Your Excellency is aware, the state of Jammu and Kashmir has not acceded to dominion of India or to Pakistan geographically. My state is contiguous to both dominions. It has vital economic and cultural links with both of them. Besides, my state has a common boundary with Soviet Republic and China. In these external relations, the dominions of India and Pakistan cannot ignore this fact. I wanted to take time to decide to which dominion I should accede to, or whether it's not in best interest of both dominions and my state to stand independent, of course, with friendly and cordial relations with both dominions. I accordingly approached the dominions of India and Pakistan to enter into standstill agreement with my state. Pakistan government accepted this agreement. Dominion of India desired further discussions with representatives of my government. I could not arrange this in view of developments indicated below. In fact, Pakistan government are operating post and telegraph system inside state. Again, Pakistan government are opening post and telegraph system inside state. Though we have got a standstill agreement with Pakistan government, that government permitted steady and increasing strangulation of supplies like food, salt, and petrol to my state. Afridis, soldiers in plain clothes, Afridis means soldiers in plain clothes, and desperados with modern weapons have been allowed to infiltrate into state, at first in Poonch and then in Sialkot, and finally in Mas area adjoining Hazara district on Ramkot side. Result has been that limited number of troops at disposal of state had to be dispersed, when thus we had to face enemy at several points simultaneously. That has become difficult to stop wanton destruction of life and property and looting. Mahura powerhouse, which supplies electric current to whole of Srinagar, has been burnt. Number of women who have been kidnapped and raped makes my heart bleed. Wild forces, thus let loose on state, are marching on with aim to capture Srinagar, summer capital of my government, as first step to overturning whole state. Mass infiltration of tribesmen drawn from distant areas of northwest frontier, coming regularly in motor trucks using Mansehra Muzaffarabad road and fully armed with up-to-date weapons, cannot possibly be done without knowledge of provisional government of northwest frontier province and government of Pakistan. In spite of repeated requests made by My government, no attempt has been made to check these raiders or stop them from coming into my state. Pakistan Radio, Pakistan Radio even put out a story that a provisional government had been set up in Kashmir. People of my state, both Muslims and non-Muslims, generally have taken no part at all. With conditions obtaining at present, in my state and great emergency of situation as it exists, I have no option but to ask for help from Indian Dominion. Naturally, they cannot send help asked for by me without my state acceding to dominion of India. I have accordingly decided to do so, and I attach instrument of accession for acceptance by your government. Other alternative is to leave my state and my people to freebooters. On this basis, no civilized government can exist or be maintained. This alternative I shall never allow to happen as long as I am ruler of the state and I have life to defend my country. I am also to inform Your Excellency is one of government that it's my intention. It's my intention at once to set up an interim government, and ask Sheikh Abdullah to carry responsibilities in this emergency with my Prime Minister. If my state has to be saved immediately, assistance must be available at Srinagar. My Menon, Mr. Menon is fully aware of situation and he will explain to you if further explanation is needed. In haste and with kind regards, Palace, Jammu, and date is 26th October 1947, Sincerely Hari Singh. So this was letter written by Hari Singh, King of Jammu and Kashmir, to Lord Mountbatten on this date, 26th October 1947. And if you want to see this letter on website, you can see this website is www.jammu-kashmir.com.documents.harisingh47.html. And this is taken from government publication in 1947. It's not private document something. So you can see why I just put this document for showing, because this is very, very important document. Now this document followed instrument of accession, which is very, very, very important one. I have told you many times, I explained to you many times, but again for reference, because I'm just including whatever references possible in this talk, I would like to put that in for purpose of everybody to reassure or refresh while discuss with. I'll say instrument accession of Jammu and Kashmir. This is a attested document written to Lord Mountbatten, as I just now narrated. And so again I'm reading, whereas Indian Independence Act 1947 provides that as from 15th day of August 1947, there shall be set up an independent dominion known as India, and that the Government of India Act 1935 shall, with such omission, additions, adaptations, and modifications as Governor General may or specify, be applicable to Dominion of India. And whereas Government of India Act 1935, as so adopted by Governor General, provides that an Indian state may accede to Dominion of India by an instrument of accession executed by rural thereof. Now therefore, I, Shriman Indra Mahendra Raj Rajeshwar Maharaj Adhiraj of Shri Hari Singh, ruler of Jammu and Kashmir, in exercise of my sovereignty in and over my said state, in and over my said state, do hereby execute this day instrument of accession, and I hereby declare that this is number one, this article for says number one of one. I hereby declare that I accede to Dominion of India with intent that Governor General of India, Dominion of Legislature, Dominion Legislature, Federal Court, and any other Dominion authority established for purposes of this document, purposes of Dominion shall by virtue of this my instrument of accession, but subject always to terms thereof, therefore, and for purpose only of dominion exercised in relation to state of Jammu and Kashmir, hereinafter refer to this state. Such functions may be vested in them by under Government of India Act 1935 as in force in Dominion of India on 15th day of August 1947, which act as in long as here and after referred to as Act. I hereby assume obligations of ensuring that due effect is given to provisions of this Act, within this state as they are applicable therein by virtue of this my instrument of accession. Then number 3 out of 1, I accept matters specified in schedules. In schedules, you may call it schedule or schedule. In schedules here too as matters with respect to which Dominion legislature may make laws for this state. Once again, like this, I accept matters specified in schedules or schedules here too as matters with respect to which Dominion legislature may make laws for this state. Then I hereby declare that I accede to Dominion of India on assurance that if an agreement is made between Governor General and ruler of this state, whereby any functions in relations to administration in this state of any law of Dominion legislature shall be exercised by ruler of this state, then any such agreement shall be deemed to form part of this constitution or the instrument and shall be constitute and have, have effect accordingly. Number 5, the terms of this my instrument accession shall not be varied by any amendment of Act or of Indian Independence Act 1957 unless such amendment is accepted by me by an instrument supplementary to this instrument. Nothing in this instrument shall empower Dominion legislature to make any law for this state authorizing the compulsory acquisition of land for any purpose. Once again, read this. Nothing in this instrument shall empower a Dominion of India, Dominion legislature to make any law for this state authorizing compulsory acquisition of land for any purpose. But I hereby undertake that should Dominion for purpose of Dominion law which applies to this state deem it necessary to acquire land, any land, I will at their request acquire that land at their expense, or if land belongs to transfer belongs to me. Let me read again. I hereby to take that I should remain. I should another that should I domain of known for purpose of dominion law, which applies in this state deemed to necessary to acquire land, any land, I will at their request acquisition, at their request acquire land at their expense, or if land belongs to me, it is to them on such terms as may be agreed upon or in default of agreement determined by an arbitrator to be appointed by Chief Justice of India. There's a confusing one. Read it again this clause. Ah. There is nothing in this instrument shall empower Dominion in legislature to make any law for this state authorizing compulsory acquisition of land for any purpose, but I undertake that I undertake that should dominion for purpose of dominion law which applies in this state deem it necessary to acquire any land, I will at their request undertake. Yes, it necessary to acquire any land, I will at their request acquire land at their expense, expenditure, or if land belongs to me, transfer it to them on such terms as may be agreed upon or in difficult or default of agreement determined by an arbitrator to be appointed by Chief Justice of India. This is another rule. This is called Article 7. Article 7. Nothing in this instrument shall be deemed to be commitment. Nothing in this instrument shall be deemed to be a commitment in any way as to acceptance of any future constitution of India or to further my discretion to enter into arrangement with Government of India under any such a future constitution. Then next one is it. There's nothing in this instrument affects the continuance of my sovereignty. Nothing in this instrument shall affect continuance of my sovereignty and sovereignty in and over this state or save as provided by or under this instrument, exercise of any powers, authority, and rights now enjoyed by me as ruler of this state or validity of any law at present in force in this state. Then last is I hereby declare that I execute this instrument on behalf of this state and that any reference in this instrument to me or to ruler of this state is to be constituted as including a reference to my heirs and successors. And then it's signed by Hari Singh and then signed by Maharaja Tiraj Hari Singh and then signed by our Mountbatten Governor General of India. He signed that both. He signed one signed on 26th. 26th, yeah, I don't, it's not written anyway. Issue 26th. And other one signed it on, yes, Maharaj signed on 26th of October 1947. And our Governor General signed it on 27th day and next day. So 27th October 1947. And there's attached casual schedule, you can say, which cites the matters with respect to which the Dominion legislature may make laws for state or defense. Naval force, naval military and air force of Dominion and other armed forces raised or maintained by Dominion, any armed forces including forces raised or maintained by an exceeding state which are attached to or operating with armed forces of Dominion. Naval, military and air force works, administration of cantonment areas, arms, firearms, ammunition, then exposure, then say naval, military and air force, works administration of containment areas, and arms, firearms, ammunition and explosives. External affairs, and says external affairs ministry, external affairs, implementing of treaties and agreements with other countries, extraditions, including surrender of criminals and accused persons to parts of high university dominion outside India. And admission into an immigration and expulsion from admission into an immigration and expulsion from India, including in relation thereto regulation of movements in India of persons who are not British subjects domiciled in India or subjects of any acceding state pilgrims to places beyond India. And then naturalization. And then says that I can say post and telegraph communication under communication says post and telegraphs, including telephones, wireless, broadcasting, and other like forms of communications. And it says federal railways, regulation of all railways other than minor railways in respect of safety, mixing, and minimum rates and fares. Then stations and services, terminal charges, interchange of traffic, and responsibility of administration of such on railways as on carriers of goods and passengers. Regulating minor railways in respect of safety, responsibility of administration of such railways as carriers of goods and services. And then maritime passengers, maritime shipping and navigation, including shipping and navigation on federal waters, on tidal waters, admiralty jurisdiction, port quarantine, and then major ports, that is to say, declaration and delimitation of such ports and constitution and powers of port authorizing sharing. Then can say port quarantine, major ports, that is to say declaration of delimitation of such ports and constitution and powers of port at authorizing authorities therein, aircraft and air navigations, provisions of aerodynamics, recognition and organization. So aircrafts and air navigations, provisions of aerodromes, regulations and organization of air traffic and aerodromes. Then lighthouses, including high shapes, beacons and other provisions for safety of shipping and aircraft. And carriage of passengers in and goods by sea or by air. Okay. Then lighthouses, including ships, lightships, beacons, and other provisions. Then carriage of passengers and goods by sea or by air. An extension of powers and jurisdiction of members of police force belonging to any limit of the railways area of outside until it's over. Then ancillary. Elections to Dominion legislature subject to provisions of Act and of any other made thereunder. Offences against law. Offences against law. Hmm. Is this found somewhere? Yes, I missed the page. Yes, offences against laws with respect to any of said matters inquiries and statistics for purpose of any of aforesaid matters, jurisdiction and powers of all courts and with respect to any of aforesaid matters, but except with consent of ruler of exceeding state, not so as to confer any jurisdiction or powers upon any courts other than courts ordinarily exercising jurisdiction of state. So this is a schedule which was authorized to our India by King of J&K Hari Singh, mandated under instrument of accession as a narrative, and this further was transmitted to another document, and that document is here. This is again very important from our point of view to link these documents, and that is Article 370 in Constitution of India, and that is, you can say, check on that, and it says that, I just repeat, it says under temporary provisions, though it's written, this is not temporary in practically, but it is a permanent one. It will just calculate it technically. But let us say 371, it says, notwithstanding anything in this constitution, provisions of Article 238 shall not apply in relation to state of Jammu and Kashmir. This article was deleted. Let's say power of parliament to make laws for said state shall be limited to. Power of parliament to make laws for state shall be limited to those matters in union list and concurrent list which, in consultation with government of state, are declared by President to correspond to matters specified in instrument of accession governing accession of state to the Dominion of India, as matters with respect to which Dominion legislature may make laws for that state. Then such other matters in said lists as with concurrence of government of state, President may by order specify explanation for this purpose of this article. Government of state means person for time being recognized by President as Maharaja of Jammu and Kashmir, acting on advice of Council of Ministers for time being office under Maharaja Proclamation dated 5th day of March 1948. In provision of Article 1, and this article shall apply in relation to this state, Article 1, which is name of this country, then such of other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as such of other provisions of this constitution shall apply in relation to this state, subject to such exceptions and modifications as President may by order specify, provided that no such order which relates to matters specified in instrument of accession of state referred to in paragraph 1 of above, subclause B, shall be issued except in consultation with government of state, provided further that no such order which relates to matters other than those referred to in last proceedings provisions shall be issued except with concurrence of that government. If the concurrence of government of state referred to in paragraph 2 of subclause B of clause 1 or in second provision to subclause T of that clause be given before Constituent Assembly for purpose of framing Constitution of state is convened, it shall be placed before such assembly for such decision as it may take thereon. Notwithstanding anything in foregoing provisions of this article, President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of Constituent Assembly of State transferred to clause 2 shall be necessary before President issues such a notification. So this is about Article 370, just the script taken from Constitution 370 article. You can go through that. What it says, there's no mention of what people are thinking about. Well, that's people confusion. Now, there's another one. This is UN resolution in United Nations Security Council, and references are given here. I just put the URL there. You can check that, HTTPS, and then undocs.org, and furthermore you can go through there are many resolutions and you can go through that. Then there is Delhi Agreement 1952, and it is that, I read this Delhi Agreement 1952. Representatives of Kashmir government conferred with representatives of Indian government and arrived at an agreement in order to endorse the main decisions of Constituent Assembly of State of J&K. This arrangement was later on known as Delhi Agreement 1952. Main features of this agreement were: in view of uniform and consistent stand taken up by Jammu and Kashmir Constituent Assembly that sovereignty in all matters other than those specified in instrument of accession continues to reside in the state. The Government of India agreed that while residuary powers of legislature vested in centre in respect of all states other than Jammu and Kashmir, in case of later, they vested in the state itself. It was agreed between the governments that, accordance with Article 5 of Indian Constitution, persons who have their domicile in Jammu and Kashmir shall be regarded as citizens of India, but the state legislature was given power to make laws for conferring special rights and privileges on state subjects in view of state subject notification of 1927 and 1932. So this is a pre-arrangement of pre-independence arrangement. In 1927 and 1932, there are some statutory powers for those people. The state legislature was also empowered to make laws for state subjects who had gone to Pakistan on account of communal disturbances of 1947. In event of their return to Kashmir, then, as President of India commands same respect in this state as it does in other units of India. Articles 52 to 62 of Constitution relating to him should be applicable to this state also. It was further agreed that power to grant reprise, pardons and remissions of sentences, etc. would also vest in President of India. Union government agrees that state should have its own flag in addition to union flag, but it was agreed by state government that state flag would not be a rival of union flag. It was also recognized that union flag should have same status and position in Jammu and Kashmir as in rest of India. But for historical reasons connected with freedom struggle in state, need for continuance of state flag was recognized. There was complete agreement with regard to position of Sadr-e-Riyasat. Sadr-e-Riyasat and through Sadr-e-Riyasat was to be elected. Though Sadr-e-Riyasat was to be elected by state legislature, he had to be recognized by President of India. Once again I read this. There was complete agreement with regard to position of Sadr-e-Riyasat. Though Sadr-e-Riyasat was to be elected by state legislature, he had to be recognized by President of India before his installation as such in other Indian states. Head of state was appointed by President and was as such his nominee, but person to be appointed as head of state had to be person acceptable to government of that state. No person who is not acceptable to state government can be thrust on state as head. Difference in case of Kashmir lies only in fact that Sadr-e-Riyasat will in first place be elected by state legislature itself instead of being a nominee of government and President of India. With regard to powers and functions of Sadr-e-Riyasat, following argument was much mutually agreed upon, and that is, head of state shall be a person recognized by President of Union on recommendations of legislature of state. He shall hold office during pleasure of President. He may, by writing under his hand, address to President, resign his office. Subject to foregoing provisions, head of state shall hold office for a term of 5 years from date he enters upon his office. provided that he shall, notwithstanding expiration of his term, continue to hold office until his successor enters upon his office. With regard to fundamental rights, some basic principles agreed between parties were enunciated. It was accepted that people of state were to have fundamental rights, but in view of peculiar position in which state was placed, whole chapter relating to fundamental rights of Indian Constitution could not be made applicable to state. Question which remained to be determined was whether chapter on fundamental rights should form a part of state constitution of India as applicable to state. With regard to jurisdiction of Supreme Courts India, it was accepted that for time being, owing to existence of Board of Judicial Advisors in state, which was highest judicial authority in state, Supreme Court should have only appellate jurisdiction. There was a great deal of discussion with regard to emergency powers. Government of India insisted on application of Article 352, empowering President to proclaim a general emergency in state. State government argued that in exercise of powers over defense, item number one on union list, in event of war or external aggression, Government of India would have full authority to take steps and proclaim emergency, but state delegation was, however, averse to presidents exercising power to proclaim a general emergency on account of internal disturbances. In order to meet viewpoint of states delegation, Government of India agreed to modification of Article 352 in its application to Kashmir by addition of following words, and these are: but in regard to internal disturbance, at request or with concurrence of government of state, it as a ends clause 1 is both parties agreed that application of Article 358, 356 dealing with suspension of Indian Constitution and 360 dealing with financial justice was not necessary. This is about that. Now let's go to this and very important part of our discussion. You can say very important it is from viewpoint what we have done now. The Bharat India Constitution of Jammu and Kashmir 1956, from record it is, and this record is from historical documents, that is Kashmir Legal Historical Documents News Network, and it's ikashmir.net Historical Documents Index. It's a government record, and it says that, and there's an amendment on this also, and that amendment is also from government records, and that also there. So now I'll first say a few paragraphs of this, because this is 24 pages and I cannot go through all pages about this constitution because these are general as we have in our constitution, but very few pages. So there's a 2 or 3 articles I just go through you, so that what purpose my interest to tell what status of Jammu and Kashmir with us was, which has been described by this government by mistake. And is this Constitution of Jammu and Kashmir 1956. We, people of state of Jammu and Kashmir, having solemnly resolved in pursuance of accession of this state to India, which took place on 26th day of October 1947, to further define existing relationship of state with the Union of India as an integral part thereof. See, importance in first sentence itself come. Once again I repeat, Constitution of Jammu and Kashmir 1956, long back. We people of this state of Jammu and Kashmir, having solemnly resolved in pursuance of accession of this state to India, which took place on 26th day of October 1947 to further define existing relationship of state with Union of India as an integral part thereof, and to secure to ourselves justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of state and status of opportunity, and to promote among us among us all fraternity, assuming dignity of individual, unity of nation in our Constituent Assembly this 17th day of November 1956, do hereby adopt, enact, and give to ourselves this Constitution. This is preamble as we have in Constitution of India, same language, no difference, only dates are different. Then Part 1, Preliminary 1, Sub Article 1. This Constitution may be called Constitution of Jammu and Kashmir. 2. This section and sections 2, 3, 4, 5, 6, 7, 8 and 158 shall come into force once, and remaining provisions of this Constitution shall come into force on 26th day of January 1957, which day is referred to in this Constitution as commencement of this Constitution. Then in this Constitution, unless context otherwise require, Constitution of India means Constitution of India as applicable in relation to this state. B. Existing law means any law, ordinance, order, bylaw, rule, notification or regulation based, made on issue before commencement of this Constitution by legislature or other competent authority or person having power to pass, make or issue such laws or ordinance, order, bylaw, rule, notification or regulation. Part means part of this Constitution. Schedule means a schedule of this Constitution. And taxation includes imposition of any tax or impost, whether general or local or special, and tax shall be construed accordingly. And any reference in this Constitution, act or law of state legislature shall be construed as including reference to an ordinance made by Sadr Riyasat. Part 2, State. State of Jammu and Kashmir. State, I have put this all on text of this video. State of Jammu and Kashmir is and shall be an integral part of Union of India. Territory of state shall comprise all territories which on 15th day of August 1947 were under sovereignty or suzerainty of ruler of state. Once again, this is very important underlined statement, which says very dominating statement, which we people could not understand. State of Jammu and Kashmir is and shall be an integral part of Union of India. Territory of state shall comprise all territories which on 15th day of August 1947 were under sovereignty of suzerainty of ruler of state. Executive and legislative power of state extends to all matters except those with respect to which Parliament has power to make laws for state under provisions of Constitution of India. Part 3, Permanent Residents. Every person who is or is deemed to be a citizen of India under provision of Constitution of India shall be a permanent resident of the state if on 14th day of May 1954 he was a state subject of class 1 or of class 2. Or Kashmir legal history documents. Now it's can say Kashmir not network having lawfully acquired immovable property in state He has been ordinary resident of the state for not less than 10 years prior to that date. Any person who before 14th day of May 1984 was a state subject of class 1 or class 2 and who, having migrated after 1st of the March 1947 to territory now included in Pakistan, returns to state under a permit for resettlement in state for permanent return, issued by or under authority of any law made by state legislature, shall on such return be a permanent residence of state. In this section, expression state subject of class 1 or class 2 shall have same meaning as state notification IL 84 dated 20th April 1927. It's 1972, 27. Read the state notification 13/L dated 27th June 1932. And then unless the context otherwise requires references may an existing law or hereby states, means all these are common. This is just two important paragraphs I wanted to refer to you for understanding what actually we are talking of. Means there is some confusion in public, means they not understand what happened, and there's confusion in the Council of Ministers itself. They could not understand they did not thorough understanding of documents and just issued something which should have avoided. And then comes the next one is ministerial document of Shimla Agreement 19th century. I've taken down from that ministerial records, and the Shimla Agreement July 2, 1972, and which is very simple language, says Shimla Agreement signed by Prime Minister Indira Gandhi and President Zulfikar Ali Bhutto of Pakistan on 2nd July 1972 was much more than a peace treaty seeking to reverse consequences of 1971 war, that is to bring about withdrawal of troops and an exchange of POWs, prisoner of wars. It was a comprehensive blueprint for good neighborly relations to exist between India and Pakistan. Under Shimla Agreement, both countries undertook to abjure conflict and confrontation which had marred relations in past and to work towards establishment of durable peace, friendship and cooperation. Shimla Agreement contains a set of guiding principles mutually agreed to by India and Pakistan, which both sides would adhere to while managing relations with each other. These emphasize respect for each other's territorial integrity and sovereignty, non-interference in each other's internal matters, affairs, respect for each other's unity, political independence, sovereignty, equality, and abjuring hostile propaganda. Following principles of agreement are, however, particularly noteworthy. And it says a mutual commitment to peaceful resolution of all issues through direct bilateral approaches, to build foundation of a cooperative relationship with a special focus on people to people contact, to uphold inviolability of line of control in Jammu and Kashmir, which is a most important CBM confidence building measure between India and Pakistan and a key to durable peace. India has faithfully observed the Shimla Agreement in conduct of its relations with Pakistan. What is agreement now? Let's see. A language of it is comments. Now, Shimla Agreement, it says agreement on bilateral relations between Government of India and Government of Pakistan. Government of India and Government of Pakistan are resolved that two countries put an end to conflict and confrontation that have hitherto marred their relations and work for promotion of friendly and harmonious relationship and establishment of durable peace in subcontinent, so that both countries may henceforth devote their resources and energies to pressing talks of advancing welfare of their people. In order to achieve this objective, Government of India and Government of Pakistan have agreed as follows: that principles and purposes of Charter of United Nations shall govern relations between two countries. So that's first important point. If you don't understand, people don't understand this. We principles and purposes of United People and purposes of Charter of United Nations shall govern relations between two countries. That two countries are resolved to settle their differences by peaceful means through bilateral negotiations or by any other peaceful means mutually agreed upon between them. Pending final settlement of any of problems between two countries, neither side shall unilaterally alter situation and both shall prevent organization, assistance, or encouragement of any act detrimental to maintenance of peace and harmonious relations. I once again read this is very important for understanding because this contains many lot of things that two countries are resolved to settle their differences by peaceful means through bilateral negotiations or by any other peaceful means mutually agreed upon between them, pending final settlement of any of problems between two countries. Neither side shall unilaterally alter situation and both shall prevent organization, assistance, or encouragement of any acts detrimental to maintenance of peaceful and harmonious relations. That prerequisite for reconciliation, good neighborliness, and durable peace between them is a commitment by both countries to peaceful coexistence. Respect for each other, respect for each other's territorial integrity and sovereignty, and non-interference in each other's internal affairs on basis of equality and mutual benefits. Then that basic issues and causes of conflict which have bedeviled, bedeviled relations between two countries for last 25 years shall be resolved by peaceful means. That they shall always respect each other's national unity, territorial integrity, political independence, and sovereign equality. That in accordance with Charter of United Nations, they will refrain from threat or use of force against territorial integrity or political independence of each other. Both governments will take all steps within their power to prevent hostile propaganda directed against each other. Both countries will encourage dissemination of such information as would promote development of friendly relations between them in order progressively to restore normalized relations between two countries. Step by step, it was agreed that steps shall be taken to resume communications, postal, telegraphic, sea, land, including border posts, and air links, including overflights. Appropriate steps shall be taken to promote travel facilities for nationals of other nations. Trade and cooperation in economic and other agreed fields will be resumed as far as possible. Exchange in fields of science and culture will be promoted. In this connection, delegations from two countries will meet from time to time to work on necessary details. In order to initiate process of establishment of durable peace, both governments agree that Indian and Pakistani forces shall be withdrawn to their sides of international border. In Jammu and Kashmir, line of control resulting from ceasefire of December 17, 1971 shall be respected by both sides, without prejudice to a recognized position of either side. Neither side shall seek to alter in unilaterally, irrespectively of mutual differences. Neither side shall seek to alter its unilateral sorry, yes, in Jammu and Kashmir, the line of control resulting from ceasefire of December 1797 shall be respected by both sides without prejudice to recognized position of either side. Neither side shall seek to alter its unity irrespective of mutual differences and legal interpretations. Both sides further undertake to refrain from threat or use of force in violation of this line. Withdrawal shall commence upon entry into force of this agreement and shall be completed within a period of 30 days thereof. This agreement shall be or will be subject to ratification by both countries in accordance with their respective constitutional procedures and shall come into force with effect from date on which instruments of ratification are exchanged. Both governments agree that their respective heads will meet again at mutually convenient time in future and that in meanwhile representative sides will meet to discuss further modalities and arrangements for establishment of durable peace and normalization of relations, including questions of repatriation of prisoners of war and civilian internees, the final settlement of Jammu and Kashmir, and resumption of diplomatic relations. Signed by Indira Gandhi, Prime Minister of the Republic of India, and Zulfikar Ali Bhutto, President, Islamic Republic of Pakistan, and this is similar agreement which we talk of. There are many more data which I not going to be able to, the 11 unit also there, I can log, you can see that one, and then there is now our changes in constitution which our government did. There is some clash appearing in there. That's the reason I'm just bringing these documents after making a lot of research on this. Clashes, if you refer to our constitution, Schedule 1 in our constitution, which says that in Eastern Kashmir is there. Yes, that is there. But it is not fully state there. You see, portion which is under Pakistan, Pakistan is called Pakistan occupied Kashmir, that is not included in our state list. Because it was not in our custody, it's on our control. Physically, we don't have it, so legally we cannot say it's in our control. This means that portion is disputed according to our constitution. You can go to Schedule 1 and see what is defined there. That portion is not our portion according to law in our constitution. Then name of that country is also Bharat according to our constitution. This is clearly given there. Now what happened in 370 and what happened further is a confusion. 370 is a clear projection of instrument of accession 1947 to our nation. There is a depiction of that. You can say a summary of that has been taken into Article 370, which people understand about land only. That is a confusion. This is not about land, it is about what law our government can pass in relation to Jammu and Kashmir and what law they can pass. That is defined there. And then if you go further, there are 48 constitutional orders which people don't know. Order number 1 to order 48, there are 48 constitutional orders which were available in our constitution, which is title is Application of Laws, Application of Constitution to State of Jammu and Kashmir, which was covered in these 48 laws, 48 orders, ordinances passed by President of India from 1947 to 1954. In 7 years, they passed these 48 orders, ordinances, which is like, you can say, it covered 260 constitutional articles, applications onto State of Jammu and Kashmir. Just 2/3 of our constitution was already applied to that state. Some portions were there which could not be resolved, but after that, their J&K constitution came into picture, which was, I think, people didn't know about this. Constitution of J&K 1956, which I just explained to you, few of the points, which mandates that Jammu and Kashmir as full, because it says territories which were in their hands in 1947. This means POK was also with you in according to that constitution of J&K Constitution 1956, are very powerful mandate by J&K state itself that we are your integral part. These territories are our territories. This is not mentioned in our constitution, but that constitution mandated that, which we people are not understanding. Now Modi is saying that we have annexed it or we have integrated now, which is a foolish statement because it was already integrated with our country in 1956, means you have destroyed that mandate because you have applied your constitution now, you remove their constitution. you apply, you remove 370, and you have done so many things which were not required to be done. It's a statement by analysis. It's not a statement by just imagination. He says on order of 2019, which President signed recently, that these titles will not be applicable. These titles were already amended in 2011. It's the amendment of 2011. These positions were withdrawn, and chief minister and this governor positions were applied. And already these fights were resolved in Delhi agreement. They said that you call this assembly as taking place on Constitutional Assembly already resolved. They again did this in this. Means there was no thorough study. There was no required homework done prior to working on this amendment. There was no, I think, legal consultant with them, or maybe these people are just doing in a haphazard way, which should not be done. So 1956 constitutional JNK constitution has been scrapped. 370 has been scrapped, which means instrument of accession has been scrapped. All these three documents, you have destroyed your story, you have destroyed your power. Now you cannot say that whole territory is with you, because that was written in JNK constitution, not in your constitution. Because they claim that's our territory, you did not claim that in your constitution. In 1950, when our constitution was drafted and approved, applied, it says only that portion with us, Jammu and Kashmir, which portion we have, that is state of Jammu and Kashmir, and not that portion POK. That's not part of our state. But their constitution said it's our part because we had it 1947, and that day was we had. That is our constitution. So there is a clash in ourselves now. I don't understand who is consultant of government, who is legal expert there, whether these people go through documents or they just sleep on them, or they work on hearsay. I don't understand what these ministers do, what these legal experts do. God's sake, they don't do anything. I think documentation has no value in this country now. People don't go through documents, and documents is everything. You go to court, you go to claims, you go to arbitration, you go to research, you go wherever you want to go, you have to depend on documents. But we people are very weak in documents, it appears to me. Professionals or not professionals, ministers or no ministers, people just talking and talking and talking on mobiles and hearsay. They don't want to see documents, they have no time for that. And that is the result, that you are missing so many things. We are engineers, we know what is document. We work on contracts, we work on specifications, we work on everything. We know each and every word has got some value. But these political people, they just don't care. And same are lawyers. I have worked with many lawyers for my cases. They also, you give them, they take it. Otherwise, they don't care. This is called defective management, defective profession. Means you are missing, you are not having any initiative to search, to find, and that makes your case defective. You lose a case because you are not coordinating your documents. You not coordinate your documents, your result is defective. You cannot claim with confirmation, with full proclamation, no, I am right. I am saying your claims are not 100% claimable. And then you lose case. So you are losing case here itself. There was no necessity to apply our constitution at this stage to that state, because already the constitution much better than our constitution. 260 articles were already applied by previous governments. So why were you so much, what you received you don't know, what you achieved you don't know, you are not able to explain what you achieved. You are simply saying we can buy land there, we can go there. Why you cannot buy land still now? It's not your state. Legally, you have lost it. This instrument accession is scrapped, that constitution is scrapped, and you're saying will buy land. You can buy only when you have now, legally speaking, practically speaking, you are just controlling it without your legal power. This is current state. And you may call me whatever you call, but fact is that you have lost that constitution. You have scrapped your power. Why did you do this? You could hold it. You could talk to them and then do it. But now you have lost. Because they say you without power of those people or without referendum, first of all, you did not conduct a referendum, which was mandatory. Every state, all 350 states which were integrated had accepted that. But only this state where there was no referendum conducted is a defective piece of paper. Even instrument accession is also defective because there was a promise made to public, promise made to all that we will conduct public acceptance. We have not done that. You may say, you may not say, you may agree, you may not agree, but fact is fact. It's not a question, it's just a part of analysis. Public must say yes or no. If public says yes, fine, no problem. If public says no, you can't do anything. It's conducted everywhere. All things signed based on that. It was a regulation under India Independence Act 1947 that you have to do this. So my purpose was to just project various documents to you for your consideration if you have time and if you are interested. But I am finding currently that it's my observation that people of this country are not interested in these documents. They are just interested in halla bol. They are interested in dancing. They are just interested in what is heard. They are not interested in what is written. And this is our Bharat, new Bharat. We don't want to see anything. We don't want to read anything. We don't want to analyze anything. We just want to accept everything what is said by our devoted people, our godfathers and our god leaders and whatever you call them. I don't name them. And those people are also working on hearsay. They don't want to read anything. And when hearsay goes to hearsay and it goes to hearsay and they also say, then what result is hearsay? And that is hearsay here. I hate this kind of film. You have to spend time, you have to work out, you have to see, you have to coordinate only, not only to see. If so there are 8 or 9 or 10 documents, as I listed there, you can see that there are so many documents written. We have to understand them, we have to connect them. And this is called work, not otherwise. You leave one, you accept two, you leave one, you accept two. That does not work in real world. People are not full who are working with them, and those miss them, they lose them sometime. And sometime, oh, you don't file this document, court will say, what have you answered? Why don't you file that? Why are you filing now? Why don't you take action that time? Missing action it is, or is legal action it is, or action it is, what it is. Then they say, you lose case. Why are we not serious? My question is again same. It's 2009. If government works like what they have done, whole parliament has befooled us. Government has befooled us. Why do not you study properly? My question is that to everyone, and even to every citizen of this country. My question is, why are you just jumping for enjoying without knowing what has happened? You are distributing sweets, you are dancing, you are doing all. Later on you are talking, you are not reading document, you are not understanding document, and you are just saying we will get land there, we will do this and that without knowing whether it's your land or not. Understand this. Do not trust anybody in this age. He may be prime minister, he may be president, or he may be God. You have to see yourself. Yes, you can depend upon them to some extent, but not to full extent, what I know now. Because there is no study done. Fools are sitting in all branches. We say alls are sitting in all branches. We say usual saying, when people are not serious, you have to be serious. If everybody thinks that I am serious and works accordingly, there shall be no error. But we are not thinking, leave it, do it, leave it, do it. We'll see later on. This kind of approach. I talk to many people, they don't, not only this issue, many issues. They're not serious, unfortunately. Only show, demonstration. We are conducting seminars, we are doing this, we are doing that. Irrelevant talks are made, conducted without any relation, and real talks are missed. That type of progress is useless. That type of progress is completely useless. We have to understand what we are doing. You have to find a new way. If you understand everything, if you coordinate everything, coordination particularly in our profession of engineering, if you do not coordinate, you cannot do engineering. Forget it. You may do design, you may do execution, you may do quality control, or quality analysis, or quality requirements, or you do safety. Whatever you do, if you cannot pre-plan, if you cannot understand, all your efforts are random. All your efforts are haphazard. Means 11th hour solution doesn't make any sense. You have a pre-solution you must have if you are an intelligent person, if you can foresee, if your mind is active. Otherwise you are a sleeping guy. Your eyes are open but you are sleeping. Mentally you are sleeping. If you are mentally sleeping, no use. Wasting time, everything. Doesn't matter you write. You must have a capacity to remember what you do. You plan, I'll do this afternoon, you think on it, that's enough. Point, you must have a point. Even that point we are not having. Oh, we'll see later on, no problem, just enjoy now. Enjoy now, then enjoy all time and suffer all time. And this happens here and everywhere. So my purpose of today was only just for projection of these documents, nothing else. We'll talk later on also about this, because I'm just talking in simple English later on. All people cannot understand, and people have complained to me many times that you are talking in English and we don't understand this, particularly people in UP, Bihar, and many other parts of our country. South people, okay, for them it's okay. For other people staying abroad, overseas, this okay. But our people usually complain that we don't understand. For the many phones come to me, many messages come to me. But what I do, you have to explain to everybody. So we'll talk to them separately, means another language, and one more session will take. But better you study this, whosoever have a chance or interested in this, because this is general knowledge. You may be appearing in certain examination, there can be a question. Maybe you are young, you are going to do IAS examination or some other examination. Any question can come, you cannot stop that. What is it? They have an answer. So I asked many people, oh, yes, if they have no solid reply, What is it? Yes, it is done very good, very good. They only answer, oh, he has done very good. But what very good has been done, nobody knows. This means lack of information, lack of material. Just accept what is said. By television said, Modi said, or someone said. You just accept what they said. No, that is not my requirement. My requirement is no fact, research, discovery, and everything. If somebody tells me something, I have to be clear about that. If there is nothing clear, then what's the meaning of telling or receiving? No meaning at all. If I don't understand, I just remain in a state of abeyance or confusion and mix up. I can't answer that. Better is read, understand, take time. Don't depend upon news, on what broadcast. They don't understand. Journalists are useless these days. 95% journalists are scrap. They are journalists for namesake only. They don't know what is journalism. Journalism is complete documentation of facts, whether it is the voice documentation or it is written documentation or it is spoken documentation. It should be fact. Fact based on analysis. They should verify. They should understand what it is. But no, just transmission only. Just your job is transmission, nothing else. Just like post office. Letter comes, do the other one. That's it. My job is over. Don't read that. Don't understand what is this. If that is journalism, I don't know the definition of journalism. You have to add your comments on that, and you can add your comments only when you understand this. But you don't want to understand that. You just pass news. We are first in news. That is your status. You are first one to tell this, to announce this. Your first one is not important. Your right one is important. Your answer, right or wrong, that is important. Your news, your statement, your relay, does it carry any meaning? If I waste my 1 hour on television and I don't find even 5 minutes good reliability, what's using of watching TV? No use. If I have a paper, Times of India, and I explaining, they are just writing something pro-government, why should I read that? You tell facts of that. You analyze and tell us reasons of that. I want to know reasons. I am paying money to you for what? Just to read pro-government statements? Why? I want to know facts. And that is why I am paying you for what? Why should I waste time in reading newspaper then? If I am not getting facts. You teach me. I want to know, because you are author of this. You have written this. You are author. You are copyright. I want to know facts. Tell me why it is. If you don't want to get it from get somewhere, ask their minister why you did this. But you are not asking. Just pass it. That's it. This is not my requirement. This is not my requirement. My requirement, give me facts, logical facts. If this happened, why it has happened? Otherwise, you are not professional. You are not at all professional otherwise. Maybe you are chief editor, you may be someone. You have no authority. You are not logical. You are useless one. If this is different age, you are right to ask Prime Minister. Why not? Prime Minister, he will tell you, he is paid for that. You ask him. I am spending money on Prime Minister, spending money on, they have to tell me why they are doing what they have done, why they have done. Why don't you ask them? When US small journalist can ask Trump, he can ask again even after Trump says no, he asks again. That is called journalist. Ask them. You are paid for that. You are taking free. You are just doing flattering to a minister. You are just buttering him. Why? I am an engineer. I don't accept what my builder, my owner says, no, this is wrong. I will not accept this. If you want me to keep, or I'll go, class. Why? I cannot do wrong because you're saying do wrong. Why should I do wrong? It's question of structure. How can I do it wrong? If because of your saying don't put water on this, I shall not put water. Same thing as journalist is. You have to question. Otherwise, we are not professionals. We are vendors then. Just the selling tomato, selling potato. No difference then. We do what the client says. Why should I do what client says? I asked one engineer, I say I reduce sizes of columns at high still because my client says that. Reduce steel also, reinforcement also. Why do you reduce? What to do? I ask architect, he says no problem. He says reduce. Is that profession? You are not considering forces, horizontal forces, other forces, because vertical forces are lesser reducer. If that is profession, then what should I say? If you say that is a profession, your engineering is valueless. Don't waste time in engineering studies. Why you do engineering studies? Why you waste so much 4 years, 5 years, then experiencing 10, 15 years, and then say I'm here? Don't waste your time of life. You are learning wrong. If you have 25 experience and you don't know what is engineering, you don't know what are methods, you don't know what is temperature of concrete, you don't know anything and don't understand anything, why you are in the field? You people are cursed to this nation. There is no quality, there is no safety, there is no anything. Maybe 5-10% people who are taking care, otherwise all are scrap. Even metro, go and see metro in Delhi. I very closely watch. Precast system, fine. Cast institute, go and see. Columns down, pillars they call pillars. You see their quality. Because they work on site, somewhere honeycombing is there, somewhere the plaster on that. It happens. So where metro is a international body like that. Precasting, that's fine, that's done in yard, that's no problem. But cast institute requires on-site quality control, on-site quality power, you can say you have to ensure that. But we are not working like that. And that's the problem. I know what quality is. I worked for 20 years overseas in many countries. I know what is there, how they work. I learned from there actually. I learned even from Arabic carpenters. I learned how they take, how they check. But why don't we have that skill? We have degrees, yes, we have MTech, we have PhD, we have this, and we have done research, only paperwork. Go to institutions, they talk only papers. Nobody talks about the practical work. So what's the use of that? If you cannot do that, you have to just show the high issue, so many papers, I've done this, all scrap, no use. If it doesn't reach field, what's the use of that? You go and see how they are keeping the enforcement, but rain is there, it was lying as on or dust or something, nobody cares, it's rusted, nobody just putting in that, nobody caring. No engineer there, no goes there, nobody goes there. What temperature concrete is 45 temperature and they are doing concrete, nobody cares. Nobody checks levels of slab shuttering, nobody checks anything. What's use? So it's only for name's sake we are engineers, and I curse myself also because I can't stop them. Who listens here? Who listens? You see bricks, you cannot call them, maybe not having 5 kilograms per centimeter square. Check that test. And nobody cares. So what should I say? Well, now topic has gone different way. I was just referring means we have to be very, very, you can say, careful people. If engineers are not careful, forget politicians cannot do anything. Because politicians are all scrap, all. Maybe 1% like Manmohan Singh or someone who are professionals. I don't consider Manmohan a politician, he's a professional. But others who consider themselves as politicians, they're all scrap, all. Well, thank you very much, no problem. I'll talk sometime else now. Today's short talk, but I have to take preparation in morning time, just 1 hour. I prepare. Thank you very much, gentlemen. Okay.